For reasons mentioned in the judgment, all these 10 regular second appeals are dismissed with cause.
May it please, Your Lordship. My Lord, one matter is item number 20. My Lord, I'm going to withdraw this matter because there is a settlement between the parties. So, my Lord, if Your Lordship can take it as number 1, Lord, I'll be obliged. Ma'am.
May I please, madam? I'm back to mention item number 40, my lord.
Yes,
My lord, I am yet to receive the paper book, my lord.
you are special PP.
No, my lord. Yeah, I'm the private respondent, my lord. Item 40. May I humbly pray, my lord, the matter may be listed after the paper book is ready. 40.
40. Mr. O, you have informed the
Yes, my lord.
Mr. O Pada, learned counsel for the respondent side, who submits that he has, who will furnish the paper book in civil cases?
The registry will prepare it.
He has not been furnished with the paper book. Hence, praise for deferring the hearing today. He also submits that he has informed the learned counsel for the appellant regarding his prayer for adjournment. Prayer is allowed. Let this matter be listed after
The paper book is ready.
2 weeks.
My lord. Obliged.
May I, Lordship? Lordship, I beg to mention item number 15. This matter is supposed to be listed for September 2, wrongly listed today.
Miss, what is your name?
Dusurilong,
D. Rilong, learned
petitioner.
counsel for the petitioner, who submits that this case was directed to be listed on September 2nd,
Yes.
2024. However, it has been wrongly listed today. Considering the submissions made by the petitioner, the registry is directed to list this matter again on 2nd of September 2024.
I'll oblige.
May I please, Lordship? Lordship, I beg to mention item number 18, Lordship. This matter may be kindly fixed on 18 September, Lordship.
When
Consent has been taken from respondent side.
18 September,
Yes, Lordship.
heard Mr.
H. Honi Tanatara, Lordship.
Write his name, who's praised for an adjournment. On what ground you are praying for adjournment?
That's Lordship. My leading counsel could not able to attend today,
Due to
Lordship.
personal difficulty of the conducting counsel, he submits that he has informed you. You are the other side.
Yes,
Also, Mr. R. Sonar, learned counsel for the respondent, who
I am for the petitioner.
who does not opposes the prayer for adjournment. Considering the submissions made by the learned counsel for the parties, let this matter be listed again on 18th of September.
May I please, Lordship? Your Lordship, I beg to mention item number 29, Your Lordship. In this matter, Your Lordship, I need to file a rejoinder reply, since respondent has filed their affidavit in opposition, and I would like to reply by filing rejoinder, Your Lordship. So 2 weeks may be granted.
You have informed the
Yes, Your Lordship, I have taken the consent.
heard Mr.
I BAM, Your Lordship. BAM.
I Bam,
My name is not there in the court.
learned counsel for the petitioner, who prays for some time to filing reply to the affidavit in opposition. In CRP, you are filing affidavit in oppositions.
Yes, Your Lordship.
This is civil revision petition.
Yes, Your Lordship. Civil division petition under Article 227, Your Lordship.
Affidavit in opposition. Affidavit in reply to the affidavit in opposition filed by the respondent side. The prayer is allowed. let this matter be listed after 2 weeks.
Your Lordship, there is an interim order, it may be
The
continued.
interim order shall continue till next day.
Highly available.
Your Lordship, I would like to mention item number 26. I beg to state that kindly adjourn the matter as our leading counsel, Bengi Arun, is not well. He is in hospital. So he could not come today.
Heard Mr. What is your name?
Tam Abo,
Heard Mr. Tana,
Tam Abo, T Abo.
write his name, who prays for an adjournment on the ground that Mr. B. Arun, who is the leading counsel for the appellant, is indisposed. Considering the submissions made by learned counsel, the prayer is allowed. Let this matter be listed again after 2 weeks on a date to be fixed by a registry.
Thank you.
My lord, I would like to mention item number 17.
Yes. What is your prayer?
My lord, interim order may be continued, my lord.
The interim will be continued, but are you praying for adjournment?
Yes, my lord.
On what ground?
Hmm. My senior is out of station right now.
What is your name?
Why Mughal?
Heard Miss Y. Mugli, learned counsel for the appellant. You have informed the other side.
Yes, my lord.
Other side counsel you have informed.
Yes, my lord.
He has given consent to your prayer.
Yes, my senior is concerned to take them.
No, have you informed the other side counsel?
Yes, my lord.
Okay. Who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the appellant. She also submits that she has informed the learned counsel for the respondent regarding her prayer for adjournment today. Considering the ground mentioned in the motion by the petitioners, the prayer is allowed. Let this be listed after 2 weeks on a date to be fixed by registry. No, your item is 20. 20 will take it first.
Lord,
You have informed the other side.
yes, I will.
Who is appearing?
Yeah.
This
Is
is withdrawal
Mr.
only,
Mr. Trafo, we have already informed.
but he has to come.
My lord, that's all. Your Lordship may see the agreement which we have entered into. Both sides we have.
You are
agreed.
petitioner.
I am the petitioner. After all, my lord, I am withdrawing the case. They are
You
not
are-
going to be prejudiced.
You are withdrawing the.
Withdrawing the CRP, my lord.
Heard
On the
Mr.
grounds, my lord.
Heard Mr. S. Datta, learned counsel for the learned senior counsel assisted by Miss. Who is
Bhutia.
assisting? Who is assisting you? Learned counsel for the petitioner. Also heard Mr.
Respondent, for respondent number 3 to 22, except 6.
R. This is item number
20.
R. Ino. Appearing for respondent number 3 to 26, as well as Mr.
E major, Your Lordship. 1 and 2 respondent.
Learned counsel for respondent number 1 and 2. Learned senior counsel for the petitioner has submitted that there has been that an amicable settlement has reached between the parties, and to that effect, an agreement has also been executed between them on 27/8/2024. And in view of the settlement reached between the parties, the petitioner does not want to, how many petitioners are there?
My lord, कितना है? Two.
Three.
One.
The petitioner does not want to further pursue this matter and prays for withdrawing the present criminal civil revision petition. Considering the submissions made by learned counsel for the parties, the prayer is allowed. This civil revision petition is dismissed on withdrawal.
Obliged. It's nice that the good sales prevailed upon them. Continuance of the case, my lord, it's a lawyer's paradise only. Obliged.
Item number 12.
Yes,
May I please your lordship? Lordship, this is a joint,
you take microphone that side instead of.
okay.
Yes,
This is a joint petition under section 482 of CrPC for quashing of FIR registered as Itanagar.
376 is there.
Yes.
At what stage the case is pending?
It's for evidence stage trial.
Charges are framed.
Yeah, charges has been framed.
Then you face the trial.
No, actually, first trial stage, during the evidence stage, the petitioner number one, who is the victim in this case, has apprised the court not to proceed further with the case because they have amicably settled the case. She has told that in said that statement before the session judge UPA. And they are family members actually, no? Very close, immediate family member. Sister-in-law, victim is the sister-in-law.
Whether the offense was committed.
Offense was actually not committed. Actually, it was a relationship of extramarital affairs. Extramarital affairs when it was known to the husband of the victim and his family member assaulted the petitioner, the accused, though who is the petitioner number one in this instant criminal petition. And petitioner number one has filed the FIR before the Bandudua police station. And in response to that, as a shield, they have the husband of the victim has used the victim to forcefully file the case before the Itanagar Women Police Station. That is the fact of the case actually. Retaliation, the case extramarital affairs is known to the husband and subsequently.
Where is the affair?
Page
22. Now, where she has retaliated, where is the statement?
FIR is in page number
22. Yes.
Where she has alleged
in the FIR as well as I think under 161, my lord.
in 161,
161 and 164 as well,
164 also she has made allegation.
my lord.
Yes, yes. Your Honor, let me clear up this. This victim, those thing has been made up. This case has been made up. And subsequently, there is no evidence. There is no medical corroboration. There is no independent witness. Even independent witness to whom the victim has said that she has seen them, seen her getting assaulted by the petitioner number one. That statement of 161 statement is also different, contrary to what she alleged.
Now, what she's saying now,
Now she is saying that
where is that statement now?
amicable, they have actually settled this case outside the court, no? So agreement they have made.
Now, what is the assurance that victim has not been pressurized to enter into that? How this court will believe you?
Actually, this is there is a two instances. Only in the strength of
No, where is
164.
that statement of the victim girl? victim?
I
How,
will this
how
one.
old is the victim?
37 years.
37.
Victim is 37 years and accused is 31 years.
Where is her statement? Now. Her evidence has not yet been recorded in the trial.
Yes, yes. But I will show you this one, Your Honor. Evidence has not been recorded, but she has submitted something before, stated before Session Judge UPIA. I will show that page number.
Yes, Mr.
Page number 28, madam, confession statement. 28.
28.
Yes, madam.
Whose statement is this?
It's the confession statement of the victim, my lord.
For victim.
My lord.
One 164 statement.
My lord.
It cannot be confessional statement. Where she has made allegations. Now, yes, you show me that statement where 164 statement victim has implicated.
Your Lordship, I will like to pray Your Lordship to look into page 83. Which is a order of Session Judge. Page 83, UPIA.
This is an admitted, page 24, Lordship. When the legal notice was issued, demand notice was issued by the complainant, that is the respondent. May I read, Your Honor?
When
the check was bounced on 24/4 of 2023, Lordship.
where is that statement?
That's then, Lordship,
When they came to know regarding bouncing of the check. When they received the information.
on the day itself, Lordship.
Where is that?
That is, Lordship, I'll just take to page 45, Lordship. That is the page 45 is the return memos issued by the bank, by the concerned bank. The date is of 31/2 of 2024. It was intimated to them on 24/4 of 2023. Let's see, page 45, Lordship.
So they came to know about this on 24/4/2000.
Yes, Lordship. They ought to have sent the demand notice on 24/5 of 2023, on or before that, Lordship.
But when they have issued?
They have issued on 19/6 of 2023. That is after 55 days.
And in the impugned order, this was not taken into consideration.
This was not taken into consideration, and Lordship, the learned CGM below has condoned the delay.
Whether delay can be condoned.
No, Lordship, that cannot be condoned. That is the criteria to issue a check bounce case. First of all, there has to be a check. After coming to know that the check has been bounced, a notice has to be issued within a period of 30 days. Then after getting the notice, after 15 days, the course of action is that right. So learned CGM has heard, so has
Heard,
not,
heard Mr. V. Jamo, learned counsel for the petitioner. This application under section 482 of the Code of Criminal Procedure, 1973 has been filed, praying for quashing of when this case was filed before 1/7 or
this was filed on 11/8 of 2023.
you have filed an interlocutory application.
That interlocutory application for stay of the proceeding before the learned CGM, not.
Yes. Praying for quashing, praying for setting aside the order dated 31/7/2024 passed by learned Chief Judicial Magistrate 0 Lower Subansiri District in CR case number 4/2023. Whereby learned trial court, whereby learned Chief Judicial Magistrate 0 has condoned the delay of 106 days in filing the complaint by the respondent under section 138 of the NI Act. Issue notice to the respondent and call for the scanned copy of the concerned case record. The petitioner shall take steps for issuance of notice. Now, what is the stage of the NI Act case?
It's for appearance of the accused person, offense explanation.
The petitioner shall take steps for issuance of notice to the respondent by registered post with AD as well as by usual mode within 3 days from the date of this order, returnable on. When is the date fixed?
It's, Lordship, I have, it's
Returnable on 19th of September 2024. Then in the IA, this interlocutory application has been filed by the petitioners in connection with criminal petition number 128/2024, praying for staying the further proceeding of CR case number 4/2023 pending in the court of learned Chief Judicial Magistrate 0. Learned counsel for the petitioner has submitted that the petitioner has filed the connected criminal petition impugning the order dated 31/7/2024 passed by learned Chief Judicial Magistrate 0 in CR case number 4/2023. where the notice has already been issued to the respondent. Stop. Learned counsel for the petitioner has submitted that the learned trial court has heard in taking the cognizance of the complaint case filed by the respondent in spite of the fact that there has been clear violation of section 138 within bracket B of the Negotiable Instrument Act 1881 as apparently the notice under said provision has been issued beyond the time of 30 days prescribed therein from the receipt of information regarding dishonor of check by the complainant. Stop. Learned counsel for the petitioner submits that in this case, notice was issued after 54 days instead of 30 days as prescribed under the statute. Stop. In view of submissions made by learned counsel for the petitioner, further proceeding of CR case number 4/2023 is stayed till next returnable date. Issue notice to the respondent in this interlocutory application also, fixing the returnable date on, which was the date given in the main case? 19 September, same date. 19 September. The petitioner shall take steps for issuance of notice to the respondent by registered post with AD as well as by usual mode within 3 days from the date of this order. List accordingly.
Duly obliged.
Item number 16.
So, I have taken step to the private respondent number 2.
This is a POXO matter.
16. I think it's close.
What is the matter?
This is a compounding of non-compounded loss.
This case is on merit as well as on compound on mutual settlement. Kindly see, Lordship, first of all,
Who is respondent number 2?
this is the complainant.
And who is the joint petitioner?
Actually, there is a defect in the petition. Although it is a joint petition, but this due to typographic error, this complainant was not made as a party. So, as per the previous order of the court, we have made as a party respondent number 2 in this petition to the complainant. That is why by hand we have corrected. Written as a complainant to a
Para serial number 135. If I take the entire contents of the FIR, this face value itself, my lord, it doesn't disclose any cognizable case, cognizable offense. And my lord, the entire records, my lord, would demonstrate, my lord, that the FIR has been filed out of, my lord, malice, just to harass the.
Who is appearing for the
respondent
number 2
is in connection with Itanagar Women Police Station, case number 34/2024 under section 61 subclause 2, 65 subclause 1, BNS and
upon respondent number 8 to 13, 15, comma 17 to 21 by substituted mode through newspaper publication, the petitioner has taken steps for the same, and the notices were published in the newspaper dated, in which newspaper?
14th August. One newspaper, Arunachal Times, and one is
What
Arunachal.
was the date of the newspaper?
14th August.
14th August is the newspaper date.
Yes, Your Lordship.
And which date is mentioned for appearance of the,
Appearance.
you
It's-
read the notice, look at
Yes,
the
Your Lordship.
notice.
It's mentioned on the 14th August itself.
You have not understood. When, which date the
Oh, it's-
defendants
oh.
were asked to appear?
Today's date.
Today's date.
Yes, 28.
Then there is some time. They may appear today. So today we will not fix it ex parte. We will see what was the last line. Newspaper, namely Arunachal Times, dated 14th August 2024, where the date of appearance of the aforesaid respondent was mentioned as 28th August 2024. That is today.
Today.
Stop.
And we have also informed, we have also intimated the parties, the respondent, but they are not coming. also.
Okay. The petitioners, the said respondents have not appeared before the court today in spite of due service of notice on them through paper publication. No, before this line, before that line, a line or agot likhibo. An affidavit of compliance has also been filed in this regard by the appellant, whereby showing due publication of newspaper, due publication of notices through newspaper as directed by order dated 6/8/2024. Thereafter, this line. What was the line? Stop. Therefore, this appeal shall proceed ex parte against the aforesaid respondents. Let this matter be listed again for, again when? 25th September
25th September.
for admission hearing.
Oblige. Your-
25th September.
Oblige.
Item number 27. Yes, my lord, I am for the petitioner.
May it please your lordship, I'm appearing for the respondent here, my lord. First of all, I'm grateful my lord has allowed me to appear online.
Yes. What is,
My lord,
why it has come up for orders?
My lord, I think the service upon the one of the private respondent has not been complete. That is respondent number 4, Sri M. Ete, who is very much required, even they made him a performer respondent, but he is one of the accused against which my complaint has been filed.
Mr. Sharma, you are appearing for?
My lord, I'm appearing for 2 and 3, my lord. Respondent, my lord. I am the complainant, my lord.
May I please, my lord? My lord, we have not served the notice to the pro forma respondent as he is also a co-accused in the FIR. That is why he has been made a pro forma respondent. So he's in our point of view, is not a necessary party, as we are here on 482 CrPC petition
No, but
for quashing of the FIR.
Washing of the FIR,
He is a co-accused. Respondent number 4.
but you have made them parties.
Pro forma.
You have to issue notice.
If so required, my lord will.
Heard, Mr.
My lord, if I may, my lord.
Yes.
My lord, I may be allowed to file an additional affidavit to bring what has happened, my lord, a parallel court proceeding who had been initiated by them against me in the Jabalpur High Court, where I got stay, where the Honorable High Court has stayed the entire proceeding. So I may be allowed to bring that on record and some material and one more judgment against Section 31 of the Hindu Marriage Act, which they have played here, that they have given, served us with notice and everything, where we have not even received the notice. So I may be allowed to bring those two judgment on record, my lord. Even though I filed my affidavit, so I'm asking leave of the court to file an additional affidavit to bring the judgment of the Honorable High Court of Raipur.
No, what this case is for? Washing
My lord,
Washing of FIR in Palukpung PS case,
FIR against the
accused, the petitioners.
you.
Yes.
And who is the respondent?
Respondent are the informants,
What is the relationship?
husband and wife and father-in-law.
You are,
I am the wife.
Okay.
Along with my family members, they have alleged under section 323, 341 and 506 and section 34 of the IPC. The charges are there in the FIR. All my family members, I am the wife.
and who is 4 and 5? Respondent number-
My lord, the respondents. The respondent number 2 is the father-in-law of the petitioner number 1, and 3 is the husband. My lord, this FIR is an aftermath, an afterthought of an FIR already lodged in.
I'm not going into that now. Who is 4, number 4?
my lord,
4 is a co-accused who happens to be a security officer during that time, at the time of the incident.
Actually, you have not even taken steps for issuance of notice on respondent number 4.
My lord.
You have to take.
But since the beginning of this proceeding, my lord, we are of the opinion that he being a co-accused,
Then
that's
why
why,
have you made him party in this?
my lord, he can be struck off at this stage also. As he is also a co-accused in the.
You file an application for striking out his name.
Well, that can be done on the order of this honorable.
my lord,
Or my lord, let me take the steps then to respondent number 4.
Yes, that would be,
Yes, my lord.
heard, Mr. What is your name?
HK Jamo, my lord.
This is.
Right. item 27, my lord. If I pray, my lord.
Heard Mr. H.K. Jamu, learned counsel for the petitioner. Also heard Mr. S.P. Sharma,
Yes, my lord.
learned counsel appearing for respondent number
2 and 3, my lord.
2 and 3. On perusal of the records, it appears that though one Mr. M. Ate has been arraigned in this criminal petition as pro forma respondent, however, notices are not yet issued to him. Stop. The petitioner is directed to issue notice to the pro forma respondent by registered post with AD as well as by usual mode within 7 days from the date of this order,
Obligement.
returnable after 4 weeks. Is there any stay here?
Yes, my lord.
No, my lord, there's no stay.
Yes,
There's
sir.
absolutely no stay, my lord.
No coercive action. My
No,
lord, may kindly see the order dated 19/6/2024.
No, my
Ni-
lord, thereafter, my lord may see the order dated 22/7/2024.
27, the matter was passed over. As,
No, my lord.
Justice Marley Wangkung was there.
My lord, my lord, I have an objection to this coercive action, my lord. This is absolutely against the Supreme Court judgment. My
Please,
lord,
my dear brother, Mr. Sharma, please at least have some courtesy, because already you cannot blow hot and cold at the same time. Already, if I have to produce a record of the High Court of Chhattisgarh, your party is have resorted for mediation. So
My lord.
kindly, at least for the next day, kindly don't misguide.
No, my
Is
lord, I'm
there-
not, I'm not misguiding, my lord. My lord, may I allow to submit, my lord? My lord may see 19/6/2024 order. My lord, it was in the meantime, no coercive action shall be taken against the accused person till the next date.
Yes, my lord. It is squarely covered by the MS Niharika
No, my
infrastructure
lord.
case.
My lord, Niharika infrastructure has been overpowered by the Supreme Court judgment of Siddharth Mukesh Bhandari, where it has been clearly stated that no coercive action business will not be taken up. Even my lord's own order. Then my lord, order dated 22/7/2024, where it came up before Justice Marley Wongkung,
My lord,
My lord,
before
on that day-
dwelling into that aspect,
My lord, why is
today
it?
learned conducting
No,
PPs.
no,
My lord.
First of all, this is not the manner in which you should make submissions before the court. You have to be, I have to hear you one by one.
Yes, my lord.
If you
Yes.
jump over one over other.
No, my lord, my
I will
learned
not-
brother is
I will
objecting.
not-
That's
If you have any objection to make, you can make that objection,
yes.
but make it in an orderly manner so
My
that
lord, my
I
lord.
can,
Yes, ma'am.
I was querying whether there was any interim protection. It
Yes.
appears that on
6/2020.
there was an interim protection which was, and there is no,
22/7. My lord, what happened due to paucity of time that day the matter could not reach. Justice Marley Wongkung, 22/7/2024.
no, but there was a mention made before the court. The councils made some submission on 22/7.
My lord, the matter did not reach. As justice, we did made a mention.
But you should have prayed for extending the interim relief.
My lord, there was a rush in the queue. It was at the last moment.
Okay. What was the last?
My lord, may I just submit here? I pray, my lord, this is absolutely, my lord, nowadays, this streamings are live.
Returnable after 4 weeks. 4 weeks. Learned counsel for the petitioner submits, learned counsel for respondent number 3 submits that he may be allowed to file an additional affidavit to bring on record certain facts relevant to this case. The prayer is allowed. The respondent number 2 and 3 may file the said additional affidavit as desired by them before the next date fixed. Stop. It appears that an interim protection was granted to the petitioner by order dated 19/6/2024. Same shall continue till.
My lord, I beg, my lord, I may just hear, my lord may hear me on this part, my lord.
No.
My lord,
same
this-
shall-
my lord,
Let me
Yes.
dictate.
Yes, my lord.
Same shall continue till next date fixed. The respondent number, learned counsel for the respondent number 2 and 3, who has objection to extending the said interim protection, may file an appropriate application for vacating the said interim order.
My lord, may I just submit here, my lord? I may allow to submit, my lord. My lord, my lord, nowadays, every proceeding is live stream, my lord. So what am I submitting? My lord, just hear me before, my lord, give conformity to the order. My lord, a day before, my lord, on 19/6/2024, this no coercive action was only till the next day. And my lord, thereafter, the matter was heard. The matter was heard, and thereafter, this coercive action was not extended. My lord, it was not extended because, my lord, on that day, it was I was there I was there, and I had produced the Siddharth Bhandari judgment, where my lord itself has followed it in the Guwahati High Court's judgment in the principal seat. That,
No, Mr. Sharma,
my lord,
we will hear your objection. You
my
file an
lord, but
appropriate-
I absolutely understand, my lord, but my lord, there's no coercive action. My lord, just I bear with you for my lord only for 5 minutes or only for
No.
2 minutes. 2 minutes, my
No,
lord.
Not today. You file an appropriate, you can file on the off date and mention it after giving notice to the other side. If it
My-
is so, we will vacate it if you file an appropriate application for vacating the order.
My lord, in criminal petition, my lord is very, very much aware, my lord. My lord, it is my lord's own judgments in a principal seat, my lord, that there's no coercive action without the charge sheet being filed has no other alternation. My lord, this is actually delaying the process. My lord may just see my FIR once that why I have filed this complaint.
No, Mr. Sharma, we are not going, today actually notices are yet to be served on one of the.
I absolutely understand,
One
my
of
lord,
the parties.
but this
So-
course,
So
there's no-
coercive action, a coordinate bench of this court has given that protection.
but that was not extended, my lord. That was not extended, and that was not extended, my lord. If it would have been extended, I would not prayed for. It was not extended. And my lord, if
Abhishek, order complete ho gaya. You may file an objection
Yes.
petition.
my
That
lord,
is the proper procedure.
You may file, if it is so urgent, you can file it today itself.
Right.
But you file an objection petition, we will consider if you file
Highly obliged.
such an.
I highly oblige, my lord.
May I, your lordship, I'm appearing of petitioner.
Yes, make your submissions.
Your lordship, scan copy of trial court record are not received
Okay.
yet from the district adjustment court Bomdila. So kindly this matter may be fixed on 4th September.
Heard, Mr. What is your name?
Sita Jo.
C. Tado, learned counsel for the petitioner. On perusal of the office note dated 5/6/2024, no, 5/28/2024, it appears that scan copy of the trial court records, which were requisitioned in this case, has not yet been received. Stop. Issue reminder to the concerned court. The registry shall take steps for issuing the reminder. Let this matter be listed again after 2 weeks on a date to be fixed by registry.
Item number 30.
May I lordship? Lordship, I have filed application of IA for corrections of the errors.
You have filed.
Yes, but I has not been solved record on today. So
You have already filed the interlocutory.
Yes.
There is any IA is there.
no, I didn't.
Learned counsel for the applicant has submitted that though the petitioner has filed another interlocutory application, however, same has not yet been tagged with the, yet been placed before this court by the registry. The registry is directed to list this matter again in the next week,
Tomorrow,
not tomorrow. What is the matter?
condemnation of delay.
Day after tomorrow. Day after tomorrow is Friday. On 30/8/2024.
God bless.
Item number 31 and 32.
May I please? My lord, this interlocutory application is filed, Lordship, for setting aside an order of JMFC. Lordship, and that order, Lordship, we could not annex in main case, Lordship, in criminal revision petition. That is why, Lordship, I before your Lordship.
Now, why this interlocutory application has been filed?
Lordship, I came to, I have no knowledge, Lordship, about this order, Lordship. That is why, Lordship, I could not annex in earlier case, Lordship. Order is, can you see page 10, Lordship, in my IA.
No, in IA, you cannot pray for that relief for setting aside. It has to be in the criminal revision application. You file a criminal revision application. It cannot be in IA.
My lord,
because that is an independent order.
yes, my lord.
You are assailing an independent order. In the IA, in the criminal petition in which you have assailed a different order. First, in the criminal petition, you have challenged which order?
My lord, in Zimma application number 26/2024.
You have challenged that.
Yes.
Thereafter, what happened?
Thereafter, Lordship, I came to know when, Lordship, I have come to submit this code. Then thereafter, Lordship, I came to know they have filed another application. And let's see page 10, Lordship.
No, you
Miss-
tell me the facts. You
Facts-
tell story.
facts-
You tell me the story.
Yes,
Let
yes,
me
my lord.
understand.
The facts is, my lord, in Zimma application, they are paying an amount of rupees 36 lakh something from my account. And in accordance with that order, Lordship, already 21 lakhs has credited in the account of the complainant, our opposite party, my lord. And now, Lordship, my two fixed deposit FD amount has got matured, and they are claiming their amount. Thereafter, again, they have filed an application, Lordship 25/7. This order I have challenged, Lordship, today.
You file a separate revision petition. That is a separate order that cannot be in a interlocutory application.
Then, Lordship, I will file, Lordship, additional affidavit in criminal revision petition number 11. Bringing facts.
Because it has,
My lord, I will file, Lordship, additional affidavit, Lordship, annexing this order, Lordship.
here you are challenging order dated 26/2024.
Yes, my lord.
26/2024.
26/20.
And in the main application, you are,
In main application, Lordship, I am challenging 26/2024.
and now
Now I am challenging 25/7/2024.
that is a separate application.
Separate,
order. It has to be tested separately. A separate criminal revision petition has to be filed. You cannot file it.
Yes, my lord, but actually, Lordship, I have no knowledge about this order. And that is why, Lordship, I have filed IA, Lordship. Then I will file, Lordship, additional affidavit, Lordship, annexing this order.
No, I don't know what you will file, but unless the order is challenged by filing a
May I please, my lord?
revision petition.
My lord, in our criminal revision petition, we have challenging the order dated 26.
26, 20.
So after filing this and after moving this application, only thereafter we came to know that another order was passed by the learned.
That has
court
to
of-
be challenged separately.
Yes, my lord. So arising out of the same case, my lord. So my lord, in that regard, we may allow to file additional affidavit by taking this order dated 25/7/24, my lord. With this criminal petition, my lord, we may allow to file additional affidavit, my lord, so that we'll
But
annex this
filing
additional affidavit.
additional affidavit will not
In
help.
criminal revision petition 11/24.
This criminal revision has been filed under 438,
Yes, my lord.
442. unless you challenge the new order under the same provision,
Yes, my lord.
you have to either amend your main application or you have to file a separate criminal revision.
My lord, additional affidavit may be allowed by this honorable court so that we can annex this second order dated 25/7/24, my lord. Because the JIMA application is filed in connection with the same case, my lord. Nahalagan PS case.
And what will happen to this interlocutory application?
Amon lordship, they are trying to getting my Amon lordship till today lordship.
Suppose court passes many orders. You are aggrieved with many orders. You will file one criminal revision and file many interlocutory applications. Can this happen? You have to challenge each order by filing a separate revision petition.
Then lordship, I may be allowed to join. I will file lordship separate criminal revision petition lordship.
These two may be considered. You assail it separately. This interlocutory application. In interlocutory application, heard Mr. A. Hussain, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the said interlocutory application with leave to file an appropriate application in that regard. The prayer is allowed. This interlocutory application is dismissed on withdrawal with leave as prayed for granted. Stop. What is there in the main application, main criminal vision?
Main application, my lord, order is first lordship notice issued on date, next date is 31st of this month.
Okay, let us wait for.
Oh, lordship.
Item number 33.
My lord, the leading counsel Modi is having a health issue. So my humble submission to this.
You take the mic.
My humble submission to this honorable court. The matter may be adjourned for today and fixed for tomorrow.
Who is not there?
Modi, my lord. This.
What is your name?
J Modi, my lord.
Heard Mr. J. Modi, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty of conducting counsel, Mr. O. Modi. Considering the submissions made by learned counsel, the prayer is allowed. Let this matter be listed after 2 weeks on the date to be fixed by registry.
Oblige.
Item number 34.
May I please, my lord? Lordship, I am for respondent number 2 in this case, and I'm on behalf of Mr. C. Modi, my senior counsel. He is out of station, and this morning we have filed an affidavit in opposition.
Who is for the complainant petition?
Your lordship, petitioner is not present today. They have today morning, your lordship, we have received the.
I am for the petitioner.
Okay, okay. What is your prayer?
The copy has been served to the petitioner. Lordship, we have filed an affidavit in opposition on behalf
Yes,
of
I have.
respondent number 2. And Lordship, since the senior counsel is out of station, so matter may be fixed for an admission hearing.
Who is out of station?
Senior counsel, Mr. C. Modi.
Leading counsel for the respondent, private respondent.
Then we'll fix it for admission hearing next day.
Yes.
This is item number.
My lordship, my humble prayer for stay the proceeding till the next date of hearing, which is under consideration on the last date of hearing.
No, I have not understood anything because of the
Kindly see the earlier order date, please.
network issue is there. Your voice is not clear.
My lordship, I will try to another way to connect with this honorable court.
No, we are fixing it when?
After 2 weeks.
What is the matter?
It is
My
a
lordship,
matter
if I am audible, kindly consider my request to stay the proceeding. Please, my lord, which is under consideration on the last date of hearing.
Washing of the FIR.
What is the stage?
Register under 420. Your lordship, stage, your lordship, we have not received anything, your lordship.
At what stage the proceeding is pending?
After registration of it's
No.
on in
Technology is not on your side.
Yes.
So,
it is on its initial stage. Only just registration of FIR.
What is his name?
Investigation stage perhaps, your lordship.
Investigation.
Yes.
Okay, heard, Mr. What is your name? Petitioner's counsel's name? What is your name? Heard Mr. S. Dahiya, learned counsel for the petitioner. Also heard Mr.
Virender
T.
Singh. Virender Singh.
Heard Mr. V. Singh, learned counsel for the petitioner. Also heard Mr. T. Ate, learned additional public prosecutor, as well as Mr. What is your name?
T by
D.
T by
T.
by
B. A.
DAI
T. by learned counsel appearing for respondent number
2.
2, who submits that they have filed their affidavit in opposition today itself. Stop. The how many petitioner respondents are there?
One only, my lord.
Only one respondent, your lordship. Respondent number 2.
Okay, the service on as the parties have, as all the respondents have appeared, let this matter be listed for admission hearing on after give a date.
My lordship, kindly stay the investigation proceeding because we are praying for questioning the present FIR.
No interference in investigation at this stage. Let the investigation go on.
11, your lordship.
Let this matter be listed again on 11th September for admission hearing.
Obliged, my lord.
Item number 35 and 36.
May I please, Lordship? Lordship, this is the applications for stay of the operations of the judgment, impugn judgment and order passed by the learned civil judge, senior division UPA, by judgment dated 16/5/2023.
In money suit or title suit?
My lord, it is the title suit, my lord.
It was title suit.
Title suit, the decree is for recovery of money.
Yes, my lord.
Yes.
How?
No,
My
it was
lord.
not recovery of money. It was because the interest was so exorbitant. So in order to reduce the interest rate, the plaintiff appellant has filed a title suit before the learned court below.
Because the respondent is imposing a interest at the rate of 15% per annum, per month. So I have availed a loan amount of rupees 20 lakhs with the agreement to repay within 6 months at the rate of 10% interest. But I have repaid out of
Now, what
15
has
lakhs.
happened to the main appeal? Notice have been issued.
Yes,
Yes, my
notice
lord.
has been
In the
issued.
main appeal, notice has issued, my lord.
The service is complete or no?
Service in regard to service that is completed. In IA, your lordship, today morning itself, I have received the copy.
What is your submission regarding his prayer?
Yes, in this case, my prayer would be, your lordship, time may be given to file
File
an
an
affidavit in
objection.
opposition. Yes.
Objection.
Yes.
You'll be filing an written objection.
Yes.
Let them file.
Then, till then, my lord, till the disposals of the main RFA, my humble prayer is that because
No, they are praying for staying the operation of.
I'm only praying for the stay of the operations of the judgment till the disposals of this RFA, my lord.
Why this so much exorbitant amount?
Actually, your
What was the
lordship,
case?
My lord, actually the case is I availed a loan amount of rupees 15 lakhs with
15
the
lakhs.
promise to repay within 6 months at a rate of 10%. However, I couldn't able to repay on 6 months, but I repaid 10 lakhs 50,000 within 7 months. So that repayment 10 lakhs 50,000 amount has been considered as interest of 7 months. That is the issue, my lord. That is the only issue. So I approached before the learned trial court, learned civil judge for declaring that conceding amount as exorbitant under Usurious Act. So the learned court below has also conceded. Again, learned court below had conceded that 10 lakhs 50,000, which I have repaid within 7 months, as interest of the 7 months. That is the issue, my lord, only. That is the only issue because I have availed the loan of only.
The trial court has dismissed your title suit.
not exactly
Not
dismissed
exactly
you.
dismissed, but I have been decreed to pay 20 lakhs despite the repayment of 10 lakhs 50,000 out of 15 lakhs. I have repaid the 10 lakhs 50,000 within 7 months, but then learned court below has decreed in against me for payment of 20 lakhs 50,000 something amount, my lord. Hence, I am before your lordship. That is the only issue here.
Though you have already paid 10 lakhs.
Yeah, 10 lakhs 50,000 I have already repaid within 7 months from the date of availing the loan. But that repayment has been.
At what stage the execution case is pending? They have filed any execution case?
No,
not yet,
Then
my lord.
where is the question of stay?
Yes. Yes.
Then let them file. Because no execution case is pending.
Yes.
Let them file the objection.
Yes.
Okay, ma'am.
Because what can be stayed is only the execution of a decree. The judgment itself cannot be stayed. Let them file an objection.
Okay.
Yes.
Okay, ma'am.
Heard, Mr. What is your name?
P. Tamin.
P.
Tamin.
This is item number
35.
36.
Heard Mr. P. Tamin, learned counsel for the appellant / applicant. Also heard Mr. K.
Posi.
K. Posi, learned counsel for the respondent, who submits that as he has made his appearance in this case today only, some time may be granted to him to file a written objection against the application for stay filed by the appellant. The prayer is allowed. Let this matter be listed again after
2 weeks.
After 2 weeks on a date to be fixed by registry.
Obliged, my lord.
Obliged.
Just a minute. In main case, 4 weeks have not. In main case, how many respondents are there?
Only one
Sole response.
You have
sole
appeared.
respondent. Yes.
Heard. In main case, heard Mr. T. S. Tapin, learned counsel for the. So, yeah. This is 35. Heard Mr. P. Tamin, learned counsel for the appellant. Also heard Mr. K. Poshi, who has made his appearance today on the stop. It appears from record that, it appears from the office note that the trial court record of title suit number 36/2017, which was requisitioned from the trial court, has not yet been received by the registry. Issue reminder for the same. List this matter after 2 weeks.
Obliged.
Obliged.
Your lordship, I apologize for mentioning at this hour, your lordship. In supplementary hearing, your lordship, item number 41 and 44, your lordship. The 41 matter was looked after by my brother G. Tado. He's, your lordship, out of station, your lordship. And item number 44, Miss T. Jini, your lordship. So I've informed both the parties, your lordship. This matter may be taken up some other day, your lordship.
On request of Mr. T. Ete, learned counsel, learned additional public prosecutor, to which the counsel for the appellant does not oppose, this matter is adjourned for today. Release this after.
September. Anytime, any day.
Release this matter after 2 weeks
Okay.
on a date to be fixed by registry.
Highly obliged, your lordship.
My
41
lord,
and 44.
item number 41, G Tato, Jati Tato,
Yes.
41. Additional government advocate.
41 and 44, your lordship.
41, in 41 mention,
G Tato.
in 41, who is the counsel?
Well, actually, G. Tado was, this matter was looked after by G. Tado, your lordship.
You mentioned that T8A submitting on behalf of Mr. G. Tado,
Yes, ma'am.
learned additional public prosecutor, prays for an adjournment, to which learned counsel for the appellant,
Amicus Curiae,
appellant, what is his name?
T Son.
Petition.
T. Son does not oppose. The prayer is allowed. Similarly, in
Item number 44.
item number 44,
T.
same,
T. Jini.
instead of appellant, learned counsel for the petitioner, M. Bose. What is? Oh, sorry, G. Singh.
Yes, sir.
Obliged man.
Now I am remembering these NIA cases.
And that series,
Yes, that series.
which you argued for 21 days.
Yes. So therefore I was wondering where I have seen you.
Deeply obliged, your lordship.
Please, Your Honor. The senior counsel is currently in court number 1. He's engaged for another matter. And we've also been informed that the PP who was engaged for this particular case is not present today.
Who was the PP? Okay, so what to be done? What is to be done?
Maybe fix.
My senior is ready for the arguments, Your Honor. However, in the absence of PP, if this honorable court will allow, then he's ready for the arguments.
Lordship, day after tomorrow, Lordship, I won't be available. So Lordship, Lordship,
And I don't want to keep it part heard.
That's why,
If
Lordship.
I see a possibility of disposal within these 3
ye-
days,
Yes, Lordship, yes.
then I'll take it up. If otherwise, keeping part heard,
Yes, yes, Lordship. Lordship, then, Lordship,
then what is your prayer?
Your Honor, he's currently in court number 1. But according to him, if this honorable court allows, then he's ready for the argument as well. But if
Lordship, let
it's
him come, then, Lordship, without PP also, we can let senior counsel maybe submit his argument, Lordship. After that, Lordship, if I would be allowed, then I would submit, then tomorrow PP may allow submit his argument, Lordship.
Tomorrow, Mr. Thado will come.
So I have to take instruction from him, Your Lordship. Otherwise, again, if he won't come, I will, Your Lordship. I will call him and
Okay,
I will.
in the
ask.
meanwhile, let us see.
Yes.
Yes, Your Honor, it
Other-
may be passed
We'll
over.
take
for-
up some other matter.
Yes,
Yes,
yes.
Yes, Your Honor.
For the time being, we are passing it over.
Yes, Lordship.
Deeply obliged.
Yes, Your Lordship. This is also part heard matter.
This is part heard.
Yes, Your
By
Lordship.
me.
Yes, Your Lordship. Your Lordship, perhaps Your Lordship remember regarding challenging the discharge order, Your Lordship. And we are on 164 statement of one of the
Discharge order, my lord, in which.
injured witness.
This statement of the, one of the witness, injured witness, has been declared as an interested witness at the stage of the discharge. So parameters of 227 and 228. Questions, my lord, whether the trial court, my lord, while.
Oh, your father.
My
Yes,
lord,
yes, Father. Yes, yes.
almost, he has concluded his argument. I have done my.
Only, Your Lordship, I will make argument in one aspect, Your Lordship. Then I will conclude.
You are supporting the.
Yes, Your
private
Lordship.
response.
Yes, Your Lordship. Why, Your Lordship, I will come to that. Your Lordship, at this stage, if Your Lordship allow, I will start, Your Lordship. Yes, Your Lordship. At the stage of consideration of discharge, for discharge of the accused, Your Lordship, the court has to consider all the charge sheet accompanied with all the materials collected by the prosecution, Your Lordship. So now, Your Lordship, even if we see the 164 statement, in my humble understanding, that will not be sufficient ground for presuming that both this accused number 2 and 3 for committing the offense under 304. This case initially has been registered under 302, Your Lordship. And later on, charge sheet has been filed under 302, read with section 34 of IPC. And then, Your Lordship, during framing of charge, the learned trial court has not found any, while committing the offense, there was absence of premeditation, Your Lordship, predetermination. So, it was 302 was altered into 304, Your Lordship.
Against
One accused, Your Lordship.
main accused.
Main accused, and trial is at the DW stage, Your Lordship, now. So, now, Your Lordship, even if we read the 164 statement and the other material, Your Lordship, first of all, Your Lordship, I will come to the medical report, Your Lordship, first. The cause of death.
Yes.
Yes, Your Lordship, the MLC is in, the medical report is in page number 61, Your Lordship, of their petition. Revision.
Yes.
Lordship will find cause of death on the column. Page number 61, column, cause of death.
Yes.
Head injury, Your Lordship. The cause of death was due to injury on the head. And now, Your Lordship, if we read 164 statement of the injured witness, and along with the other witnesses, Your Lordship, then, Your Lordship, it can be inferred that whether there is a sufficient ground to presume that the accused has been committed the offense under 304 or not, Your Lordship. sufficient ground. Because your lordship, learned trial court has no doubt has stated that it's an interested witness, but in the later part it has said that there is not a sufficient material to prosecute under 304 against both the accused. Accused number 2, A2 and A3, your lordship. Now, your lordship may kindly come to the statement 161 statement of the main accused who is under trial, your lordship. That is in statement is in your lordship page number 32.
Yes.
Your lordship, there's no required to read all the part, but it is from your lordship from below your lordship 7 line here. I also apologize from there, your lordship, from below. I also apologize. I also apologize, but he started verbally abusing me, so I pushed him in order to save myself. As I was being punched and kicked, despite of requests not to assault me, when he fell down, I sat upon him and punched him wherever I could. Thereafter, seeing him unconscious, I fled from the area. Unconscious, your lordship. He punched him till he became the deceased become unconscious, your lordship.
This is the
Main accused which is under trial, your lordship. Against him, there is a material, your lordship. Grave suspicion is there against this person, but against the co-accused 2 and 3, your lordship, there is no doubt suspicion is there. So far as 164 statement is concerned, it says that he has seen 3 of them. 161 is totally different, your lordship, but in 164 he said, I have seen 3 of them assaulting the deceased, but he has not stated that while assaulting he become unconscious. He only says, I have seen them assaulting the deceased.
Where is the 164?
Your lordship may kindly come to page number 47. Start from 47. Now we can, your lordship, from 48, your lordship, it will start, your lordship, the part. I will read from page 48, your lordship. On hearing me, the 3 of them got angry and got up from their seat, and this CJ boy pushed me and he punched me on my face. The other 2 boys were also supporting CJ, as they did not stop him and seemed to be encouraging him by laughing at me. Due to the punch, I fell on the ground, and when I got up and tried to fight, my girlfriend and her 2 friends and Komi Yami told me not to fight. My girlfriend and 2 friends then took me near my scooty, and just when I was about to start scooty, CJ came and punched me from behind, saying so and so. The moment I heard him, I turned around. He then punched me on my face. The 2 boys, Mosu and Komi, also joined CJ and started by pinning me on the ground. My girlfriend and her friend were trying to stop them, but they were drunk and refusing to stop beating me. One of them even strangled, and one of them even hit me with a sharp object on my face tight. I still have injured mark till today. I almost become senseless from the blow and punches delivered on me by 3 of them. The 3 girls were trying to stop them, and as I was bleeding from my face, and at the time I checked my pocket and found my phone, so I called up friend Kyoda Tama. This is the deceased person, your lordship. As his number was on my latest dial list, so I asked him to come and help me. I was badly beaten up. The 3 girls somehow managed to talk to Chije and his party. After some time, my friend late Kyoda Tama came to the spot, and he saw me and was talking me. And on seeing him, the 3 boys attacked him and beat him. My friend was trying to defend himself, and they kept beating him till he went inside the house gate. I tried to stop them, but Mosu and had punched me once again. As I was also injured, I could not be of any help to my friend. Now it comes here. I think one of them even hit Tama with a stone or a brick, which were lying nearby, as Tama has severely injured on face and body. I then saw Tama lying senseless on the ground inside the house gate. Me and my friend Tama was taken to the hospital by some of my other friend who reached the spot after we were both beaten up. The entire incident took place at around 1 a.m. and so on and so. Here, Your Lordship, it says, I think, Your Lordship, one of them. No doubt from this statement, Your Lordship, the suspicion arises, Your Lordship. Yes, three of them has committed the offense. But, Your Lordship, to the extent whether 304, because it has been charged under 304, and statement of the, Your Lordship, the accused who is under trial, he says that he punches him till he become unconscious. This part is not there, Your Lordship. It says they have assaulted. So suspicion is there, Your Lordship. But without anything more against these two accused, it would not, in my humble understanding, Your Lordship, it would not be sufficient for framing charge against both of them under 304. So that much, Your Lordship. And other, Your Lordship, to substantiate my submission on, Your Lordship, whether the suspicion alone will be sufficient to frame charge frame or not, Your Lordship. On that, I will just rely on judgment, Your Lordship. 2010 to SCC, Your Lordship, 398 page. Your Lordship, para 10 to 15, but I will rely para 10 and 15, Your Lordship. Para 10, Your Lordship. Before considering the merit of the claim of both the parties, it is useful to refer to section 227 of the Code of Criminal Procedure, which reads as under. If two views are possible and one of them give rise to suspicion only, as distinguished from grave suspicion, the trial judge will be empowered to discharge the accused, and at this stage, he is not to see whether the trial will end in conviction or acquittal. Further, the word not sufficient ground for proceeding against the accused clearly shows that the judge is not a mere post office to frame the charge at the behest of the prosecution, but has to exercise his judicial mind to the fact of the case in order to determine whether a case for trial has been made out by the prosecution. In accessing this fact, it is not necessary for the court to enter into the pros and cons of the matter or into a weighing and balancing of evidence and probabilities, which is really the function of the court after the trial. Now, Your Lordship, may kindly come to para 15 directly, Your Lordship. In a recent decision in Soma Chakrabarti versus State, this court has held that the settled legal position is that if on the basis of material on record, the court could form an opinion that the accused might have committed the offense, it can frame the charge. Though for conviction, the conclusion is required to be proved beyond reasonable doubt that the accused has committed the offense. At the time of framing of charge, the probability value of the material on record cannot be gone into, and the material brought on record by the prosecution has to be accepted as true. Before framing a charge, the court must apply a judicial mind on the material placed on record and must be satisfied that the commission of the offense by the accused was possible. Whether in fact the accused committed the offense can only be decided in the trial. Charge may although be directed to be framed when there exists a strong suspicion, but it is also treated that the court must come to a prima facie finding that there exists some material. Therefore, suspicion alone, without anything more, cannot form the basis, therefore, or held to be sufficient for framing charge. From this, Your Lordship, what I'm trying to project is, Your Lordship, that statement of the 164 statement, no doubt it casts some suspicion over these two co-accused, Your Lordship, but it's not a grave suspicion. Regarding, Your Lordship, he has not stated that after seeing them assaulting by three of them, the deceased become unconscious and then he was evacuated to the hospital. It simply says the three of them were assaulted. And so far as the other incriminating material is concerned, the statement given by the main accused, he has stated that categorically that he has punches the deceased until he become unconscious, Your Lordship. there is a material against the main accused, your lordship. But so far as the two accused is concerned, suspicion is there, your lordship, but it's not of a grave nature, your lordship. Grave suspicion to charge frame under section 304, your lordship.
When can the accused be discharged in the case? What are the conditions? What are the criteria for discharging an accused?
Your lordship, at this stage, whether there is a ground to presume that the offense has been committed by the accused, and not whether the ground for convicting the accused, your lordship. Presumption, your lordship, because the section which has been charged is 304, your lordship. Under 304, charge has been framed, your lordship. And main accused who has assaulted, so far as the material is concerned, that person is under trial, your lordship. But so far as these two accused, for them, your lordship, 304, in my humble understanding, your lordship, for 304, there is not a sufficient ground, your lordship.
May not be under 304.
Yeah, maybe other, but not under 304. Yes, your lordship.
Maybe under other.
Yes, your lordship. And they are not disputing, they are not assailing the framing of charge under 304, your lordship. They are not disputing the charge which has been framed under 304. They have challenged the discharge order, your lordship.
Discharge order.
Yes, your lordship.
So, is it a case of discharge? That has to be seen by this court in this revision petition.
Yes.
That is it a case of discharge? If not a case under 304A, then
maybe for your lordship, for other offenses, your lordship, but not for 304, your lordship.
no, the trial court has discharged them. That means no materials are there.
Yes, you're no sufficient on the ground that there is no sufficient material.
Trial court is not bound that the charges have to be under 304 only.
Yes, yes. Your
It
lordship.
could have framed charges
Yes, your
under lesser sections.
Yes, your lordship.
If there are any material.
Yes,
So my query to you is it a case where there is no material, no charges could have been framed?
But for other, your lordship, to substantiate the other one, the injury has to be looked into again, your lordship.
He ultimately died.
Yes, he died, your lordship.
So the injured victim is saying that they started beating him and continued to beat him till he entered into a
Gate.
gate.
Yes.
So it is not only one punch, or he has not detailed in, but he stated that all of them beat the deceased and continued to beat him.
Yes, your lordship.
So is it a case where we can exonerate?
Not under your lordship 304, but I'm not on the other aspect, but for the 304 is not sufficient. That is my only limited submission to that extent, because they have not challenged it, your lordship. The charge under which the main accused
They
has
are
been.
not challenging the framing of charges against the co-accused. They have challenged the discharge order.
Yes, your lordship.
That the co-accused has been discharged. So we have to see, is it a case of discharge, or could any other charges could have been framed? Whether any other charges could have been framed?
For other charge also, your lordship, there must be a material, your lordship.
So your submission is, in this case, there is no material.
The material is there, but it's not sufficient, your lordship.
Okay. No, we have to distinguish whether is it a case of mere suspicion or
A grave
at least
suspicion.
some materials were there. His submission is that court has ignored some materials. Court has ignored the statement of injured witnesses on the ground that court said that he is an interested witness. Therefore,
Yes, your lordship. If the statement is discarded in toto, then there is no material, no doubt, your lordship. But if 164 is taken into consideration, then even on that aspect, Your Lordship, I am submitting, even on that aspect, Your Lordship, to prosecute them under section 304, the offense which under which they have been charged, the offense has been charged, charge has been framed. For that, it is insufficient in my humble understanding.
They are charged under section
304, Your Lordship.
finish.
That much, Your Lordship. The other side is the private, the counsel for the accused persons are there, Your Lordship.
No, before you conclude,
Yes.
what other petition? You have relied on only this one.
No, no, Your Lordship. Prior to that, also, Your Lordship, I have relied on Tarunjit Tejpal case, Your Lordship. Tarunjit Tejpal.
You've given a copy of that.
Yes, I have given a copy, Your Lordship. Yes, Your Lordship, I have given it, that's reported in 2020, 17, 556, Your Lordship. Your Lordship, I have not provided the soft copy, but the book. I will furnish the soft copy, Your Lordship.
What is the citation?
2020, volume 17, SCC 556, Your Lordship. And I've relied para 18.1 to 18.5, 8.1 to 8.5.
8.1 to
8.5.
Okay, yes. Yes.
May I submit?
You are for?
My lord, I am for the private respondent 2 and 3. The accused number 2 and 3.
What is your name?
KPOSI.
K-P-O-S-H-I.
POSI.
P-O-S.
Yes.
Yes, Mr. Poshi.
My lord, before coming to first of all, I would like to apprise the fact of the case. So in order to understand the case properly. Your Lordship, the fact of the case is that on 5/11/2021, this accused number 1 and number 2 and 3, they were invited by one of their relatives at their residence at Naharlagan, the helipad area. They were invited for dinner and they went to the resident of one Yami Komi, Your Lordship. The Yami Komi is the eyewitness in this entire incident, Your Lordship. So they went to the house of the Yami Komi, Your Lordship.
Yami Komi.
Yes. Yami Komi, she is also, her statement has been recorded once, 164 statement has been also recorded. So they went to the house of the Yami Komi and they were there in the house of the Yami Komi. Suddenly what happened, Your Lordship? This one of the witness, that is my learned friend had said that he was the injured witness, that is one John Tapping. So when they were in the house of Yami Komi, this John Tapping was roaming around the house of the Yami Komi. When Yami with her girlfriend, that is Dechang Gyana, Your Lordship, and Dechang Gyana's statement has been also recorded during the investigation, Your Lordship. Even she has been examined as in PW in the case, in this trial of the case, Your Lordship. So what happened, Your Lordship? They were in the house, and the John Tapping and Dechang Gyana, who is the happened to be the girlfriend of the John Tapping, Your Lordship. They were roaming around the house of the Yamikomi, and Yamikomi seen them. She invited Dechang Gyana to her house because this Dechang Gyana was the relatives, and she was belonged to the same place of this Yamikomi, Your Lordship. So she invited her. So when she invited one John Tapping, she came with Dechang Gyana, and they both accompanied with the accused persons, Your Lordship. There were 3 accused persons. 3 accused persons were already in the house of Yamikomi, Your Lordship. They accompanied there, and they started to take some drinks, Your Lordship. And at that point of time, the Yamikomi was preparing a meal dinner for them. So what happened, Your Lordship? During they were in the room, they introduced each other. So at that point of time, this accused number 1, number 2, and 3, they did not know the John Tapping, who is said to be an injured witness. So he was introduced by one Dechang Gyana that he is my boyfriend. So accordingly, what happened, and they asked the main accused person, Your Lordship, prime accused person, one Tanu Chiji, asked him that where are you from? And on reply, he said that he is from Bukar community. So by hearing that, he asked him to say something about the Bukar language. So there was, so he could not speak properly of Bukar language. So there was a altercation in between the John Tapping and the main accused person, that is Tanu Chiji. There was an argument in between them. So he felt that he was insulted in front of her girlfriend. So there was an altercation. So in the process, there was a fighting in between the main accused number 1, and the John Tapping, who is said to be the injured witness in this case, Your Lordship. There was a 2 incident, Your Lordship.
Who is accused number 1? Tanu Chiji.
Accused number 1 is a Tanu Chiji, Your Lordship.
And who is the injured witness?
Injured witness, said to be injured witness, is John Tapping, Your Lordship.
And deceased name is?
Deceased name is Kodatama, Your Lordship. So there was a, Your Lordship, altercation, and there was a fighting in between the accused number 1 and the injured witness, John Tapping, Your Lordship. So when they were fighting with each other, the Yamikomi who invited them, she intervened into the matter, and she dispersed the accused person, accused number 1, and the injured witness, Your Lordship. So accordingly, in her intervention, they dispersed and they leave the spot also. John Tapping leave the spot with her girlfriend, Dechang Gyana. Then after a while, again this person came back in the house of Yamikomi, where accused number 1, 2, and 3 were there. Again came back. Then again, there was an argument and there was a fighting in between the accused number 1 and the injured witness, Your Lordship. So accordingly, what happened, Your Honor, Lordship, after that, when he was caused injury by the accused number 1, he invited one of his friends, that is deceased, Your Lordship. The deceased was at Dame site. At that point of time, he was at Dame site, which is 1 kilometer, approximately 1 kilometer away from the PO, the place of occurrance, you know. So he invited his friend where by telephonically, he invited the deceased person. So deceased person, after his invitation, deceased person came to the spot with one of the his friend, that is Tadarar, who he was also, Your Honor, Your Lordship, his statement was also recorded. The statement of Tadarar was also recorded. So, Your Lordship, this incident was happened with the John Tapping and the Tanuchiji, the main accused person, not with the deceased, Your Lordship. So deceased was invited by the John Tapping himself. So accordingly, John Tapping invited, and the deceased came to the spot, and there was a fighting, and there was many boys and girls were there on the process, Your Lordship. So there is no any fighting with the deceased person and the accused number 2 and 3. The accused number 2 and 3 did not assaulted the deceased. The eyewitness, that is Your Lordship, the Yami Komi, who is the one of the eyewitness, and Dechangyana, who is the eyewitness of the incident, they never stated that the accused person number 2 and 3 were assaulted the deceased, Your
One
Lordship.
of the girls said that I saw one of the accused. Out of these two,
yes,
somewhere one girl has said that I saw out of these two private respondent, one had assaulted.
that is there, Your Lordship, but it
Who
is
said so?
that is not there. One of them, that is not specified there. Who has assaulted him?
Yes,
That
Mr.
is not
Kumar,
specified, Your
look
Lordship.
to that portion,
My
where,
lord.
where that, No.
Page number 4951, my lord.
just a minute, I'm interrupting.
Yes.
Page number 49.
49 to 51, my lord.
Who is that girl?
Girl is, my lord, Yami Komi Yogam. Page 50, my lord. Page 50, third paragraph, my lord, from the bottom. 1, 2, 3, 4.
After they left, I heard noise
Yes.
outside the house. After Shan finished his food, immediately I rushed so and so.
My lord.
I went to ground floor and saw Tanua and John. Tanuchiji
My lord, page number
and
50.
John fighting with each other.
My lord, 50 page number. 50, my lord.
Who is Shan?
Son is the one of the
private respondent. Even Shan joined the fight.
Yes, other boy would come with John.
There is one statement, slight statement is there, that even Shan joined the fight. That girl is not interested. The girl is the girl in whose house the incident happened.
Yes, is Yami Komi.
Yami is the
This is the statement of Yami Komi, Your Lordship.
So you have to on this Mr. Ete, you have to again refresh after him that how to deal with this statement. The girl implicating Shan. Okay. Girl said that Shan also joined in the fight. Yes.
Yes. In this case, you are not, only she said son is joined in the fight, but it is not specified that whom he has assaulted. That is not specified, Your Lordship. So there must be some specification must be there, and particularly there must be that the accused person has assaulted the deceased. That must be there, Your Lordship, and that ingredient is not there at all, Your Lordship. And Your Lordship, the petitioner has projected this case only on the statement of the John Tapping, who is said to be an injured witness. But in this present case, Your Lordship, they says that the John Tapping is an injured witness, but they have not substantiated that he was an injured witness. He was, of course, he was there, but there was no injury. No injury report is there. They cannot substantiate that there is an injury report. There is no injury report. So he cannot be an injured witness. But he can be an eyewitness, Your Lordship.
No, but you are admitting that he is an eyewitness. That is enough. Because injured witness is only to show that as he sustained injury, he would have been present in. So he is an eyewitness. You are saying he is not an injured witness, but he is an eyewitness.
Yes, he was there in the spot, Your Lordship. He was there. But his statement, 164 statement has been improved, Your Lordship. Your Lordship, in his statement under 161, he did not say anything against the accused person or the accused person, accused number 1 and 2. So if the accused number 1 and 2 was caused any injury to the deceased, he must have ought to stated before the IO of the case. 161 statement, when his 161 statement has been recorded. At that point of time, he must have ought to stated that, but he never stated in 161 that the accused person 1, 2, and 3 has also assaulted. But in subsequent statement, that is 164, he stated that the accused number 2 and 3 also assaulted. This is merely stated that they have assaulted, but how they have assaulted, that is not specified, Your Lordship. With punch or kick or whatsoever, it is not stated, Your Lordship. So on the merely he merely stated that they have assaulted. That cannot be, Your Lordship, constitute any offense, Your Lordship. He must stated that the accused person 1 and 2 have assaulted the deceased with stone, with something else. There must be that must be there, Your Lordship. But it is completely absent, Your Lordship. There is no any specific statement of in that regard, Your Lordship. And Your Lordship, initially the case was registered under 302, Your Lordship. But at the stage of framing of charge, the accused number 1 was charged under 304, Your Lordship. So Your Lordship, to commit any offense, there must be some intention must be there and some motive must be there. So to commit any offense, there must be a motive or intention must be there. So in this case, Your Lordship, in the present case, there is no any element of motive or element of intention was not there. Mens rea was not there, Your Lordship. There completely the absence of mens rea is there. They have no intention to cause any deceased persons, Your Lordship. Though they have
No, then
fighting.
why they assaulted without any motive? They might not have intended to kill him. But if we believe that they have assaulted,
No, Your Lordship. Their fighting was with the John Tapping, not with the accused deceased, my lord.
no. What I am putting query is that assuming that we believe the statement of John Tapi that they assaulted. Then the question is to be seen whether John Tapi's statement can be taken into consideration while framing charge assault. Trial court has totally discarded the John Tapi's statement on
Yes.
the ground that he appears to be an interested witness. So he has not stated same thing before police in 161. After 45 days, his 164 was recorded. So he got sufficient time to improve upon. So he's telling lie. This is the time.
Yes, yes.
But can this be done at this stage of framing of charges? That
Yes.
is my question.
Yes, my lord, that can be because section 227 it clearly says that there must be some material against the accused person to frame a charge. So in this present case, your lordship, there is nothing material against the accused persons 2 and 3, though there is a material against the accused number 1, but for accused number 2 and 3, nothing material is there. Only on the mere statement of the John Tapping, that 2 is recorded after the lapse of 45 days. He was ought to be recorded within a week or week, but it was recorded after 45 days, left of 45 days. So it is completely a improvised case of improvise. His statement has been improved, your lordship, because there was a pressure on him because he called the deceased person. Deceased person was at somewhere which is far away from the place of occurrence. So because he called the deceased person, so there is a pressure from the parents of the deceased person. So he might have stated, your lordship. So there is a suspicious of his statement of 164. So this case has been projected only on the basis of 164 statement of the John Tapping, your lordship. So he was the first person who have initiated the fighting with the accused persons, your lordship. So later he invited the deceased, your lordship. Now, your lordship, at this stage, your lordship, now the trial of the case is on the verge of completion, your lordship. It is in the verge of conclusion, your lordship. Trial is on the stage of defense witnesses, your lordship. And your lordship, in the during the trial, this accused number 1, he himself has examined himself as.
During trial, John was examined as.
Yes, John was examined, your
as
lordship.
Witness number?
Is
SPW?
he was examined as, your lordship, as PW3.
Whether he has stated anything against these discharges?
He stated against the accused person, but that too is different from the 164 also. And his statement is different from 164. In 164, he stated that the accused three boys were assaulted. This is, but during deposition, your lordship, during the time of during the trial of the case, he deposed before the court on oath that he was the accused. May I read, your lordship?
Only the relevant portion.
Yes, relevant person. That is, your lordship may kindly
Page.
come to my affidavit in position, that is page number 18.
Page 18.
Yes.
Yes. Yes.
Yes. May I read you? That will be start from para 8.
What is the name of these two respondents?
Name of two respondents is one is Yamik San Mosu and another is Doi Komi. Doi Komi.
Doi Komi and Sang Mosu.
Yes, San Mosu and Doi Komi. Accused number 1 and 2 and 3. May I read you?
No, there is a statement.
Yes.
Whether to rely.
Yes, in this
Well,
case, your
He
lordship.
gave that statement that they indiscriminately assaulted.
Yes.
But they were not facing trial at that time.
In this in his statement, your lordship, there is indiscriminately what is there, your lordship.
Yes.
But in 164 statement,
But in spite of that, 319 was not invoked. In spite of this statement,
Well, 319 cannot be invoked.
because he was
already investigation took place those 2 cases. There is a judgment on that.
discharge accused.
Yes.
But you are saying
If my learned friend has not properly placed the law point on that one. Under what circumstances 3-1? The question is that whether by way of 319, the co-accused who has already been discharged under 227, whether 319 can be
invoked
used
on-
or not. The law says
That day you-
constitutional bench judgment.
So it's there, your
No,
lord. It can be
cannot.
invoked, your lord.
Yes.
One by
It
one.
can be invoked. It can be invoked.
You have that judgment.
I will.
with you. You make your submissions on that. Whether against an accused who has been charge sheeted, then discharged, whether 319 can be invoked against such a,
Yes, yes.
if later on some materials come.
Yes.
There, your lord. I will produce.
So your lordship, there indiscriminately word is used by the John Tapping, your lordship. So 164, he says they were assaulted. So there is an inconsistency in the statement of the John Tapping, your lordship. So we cannot rely the statement of the John Tapping, your lordship. His statement says 164, his statement says something else. In deposition, he says something else. So we cannot rely on his statement. So his statement is inconsistency. So when the statement is inconsistency, we cannot rely on it. And your lordship, during the your lordship trial of the case, this accused number 1 was also your lordship examined himself as a DW1. In his deposition, your lordship.
Yes, what is it?
Yes. DW1, your lordship, page 64.
'64 of the appeal memo.
Yes, no, your lordship. Affidavit in opposition that I have filed. Page 64, annexure 3, your lordship.
Yes.
Yes. From the bottom, your lordship, the last paragraph. The second, third last line. Your
Thereafter,
No, your lord, John Tapping. It will start from
John Tapping.
Yes. John Tapping, after being intoxicated, again started quarreling with me on the same topic, and we had fight. After some time, John Tapping some of his friends from his mobile. Accordingly, some boys came at the residence near Srimati Yamikomi in 2 to 3 bites. One of friend of John Tapping caught hold of my collar and by taking me in a corner started assaulting me. I was assaulted by all the friends of John Tapping. I observed that one person was giving me punches and kicks, to whom I gave back some punches, and when he did not stop, I pushed him with all my strength. Later, I came to know that the person whom I pushed had expired. Somehow I escaped from there and ran away to the residence of my girlfriend's Miss Yarda Menam at Polo Colony. This is Your Lordship, the position of the main accused, Tanuchiji, Your Lordship. He admitted that he had assaulted the deceased, Your Lordship. So there is a case, there is a prima facie case against the accused number 1, Your Lordship. So he stated clearly on oath that he had pushed the accused deceased, Your Lordship. And later he came to know that he was expired. So he admitted that the deceased was assaulted by him. So there is no case against the accused number 2 and 3, Your Lordship. So my humble prayer before this honorable court is that this present criminal revision petition may be dismissed, Your Lordship.
Before that, which judgment you were referring to?
319.
319?
Yes.
319.
Yes.
Yes.
This is for the Taranjit principal case earlier I moved for 227. Now I will proceed for 319. That was for
Arun Teshwa. This you referred why?
for
8 point, 8 point.
8.1 to 8.4. All the cases in mix up, you know.
That is law on 227, 228. How to interpret 227 and 228. That is discussed in
Yes.
here. Which judgment you were referring to?
Supal Singh Khaira, Your Lordship. The 2-3 judgments are there, Your Lordship. And recently also, Your Lordship, in case of Your Lordship, this difference between Your Lordship when once the accused has been discharged, and if the accused has never been part of the investigation, in what are the procedure to be followed? And that case, Your Lordship, when the accused is discharged, the court has to make an inquiry first, meaning thereby the opportunity has to be given. But when the accused has never been a part of the investigation, or has never been or has not been discharged, in that case, the court has held that for that there is no any question of giving him the opportunity. Court can proceed directly, Your Lordship. These are the judgment, Your Lordship.
But if he has been discharged, still he can be made an accused.
Yes, Your Lordship.
Again.
There are so many, Your Lordship, judgments are there, but I only have that one copy of each, Your Lordship.
No, you need not to give it to me. You just let me the citation. Not many judgments, only
Yes,
relevant judgments.
Yes, Your Lordship.
Supal Singh.
Parsis, Your Lordship, 2023-9.
2023.
9.
9 is CC.
C, yes, Your Lordship. 108.
108. What has been
Yeah,
said in this?
I will
case?
come to your lordship here. One expect regarding what I've submitted, your lordship. When the accused has been discharged, then what procedure are to be done before exercising 319, your lordship? I will read, then I will come to the other parameter. There are 23 and 24, your lordship. Section 227 CrPC provide for discharge of an accused. If the court finds that there is no sufficient ground or reason for proceeding against him, consequently, the proceeding against discharged person is dropped. On the other hand, under section 319 CrPC, a person who has not been named as an accused in the summon to be tried, along with the other accused, while 227 result in conclusion of the proceeding against a person which is an accused on his discharge. On other hand, a person who is not accused in summon to be tried, along with other accused under 319. A reading of the said section would clearly indicate that the power is given to the court to proceed against any other person appearing to be guilty of an accused. The expression proceed as appear in section 319 is of significance. The exercise of power 319 CrPC is not at initial stage where cognizance is taken of the offense and summoning the order is passed before committal of the matter to session court. The power exercise under 190 is quite distinct from the power exercise by trial court, session court under section 319. In our view, much significant turn on the expression proceed. In section 319 CrPC, the said section came up for consideration before this court in innumerable cases. However, it is of relevance to mention the constitutional bench judgment in Hardeep Singh, Sukhpal Singh Kaira versus State of Punjab and Biranjan Singh versus State of Rajasthan. The relevant para of the Hardeep Singh case, your lordship, is here. Now, your lordship, I will directly come to the operating portion actually. Your lordship. Now it's 22 point. Your lordship, now I will read the operating portions. Para 23. From the aforesaid observation of the Constitution Bench of this court in Hardeep Singh, it is noted that an inquiry is contemplated as against a person who has been discharged prior to the commencement of the trial in terms of section 227. As extracted above, but on the inquiry, if it appears that there is evidence against such a discharged person, then power under 319 can be exercised against such a discharged person. Here it clearly says, if under 227, an accused has been discharged, and later on, if court find that there is a material, if unrebuted lead to conviction, then court can give an opportunity to that person. However, that will not available to the other accused. This clearly would mean that when a person who is not discharged, but is to be summoned under section 319, on the basis of satisfaction derived by the court on the evidence on record, no inquiry or hearing is contemplated. This is for the other accused, but for 319, for 227, accused who is discharged under 217 is permissible, your lordship. Here also it clearly says, relying on all the judgment, constitutional bench judgment, your lordship. This would clearly indicate that the principle of natural justice and opportunity of hearing a person summoned under 319 CrPC are not at all contemplated. Such a right of inquiry would accrue only to the person who is already discharged in a very same proceeding prior to the commencement of the trial. This is different from the holding that a person who has been summoned as per section 319 CrPC has a right of being heard in accordance with the principle of natural justice before being added as an accused to be tried along with the other accused.
Now, why are you referring to this case? What is your submission?
No, your lordship,
That
why?
the accused could have been
Now,
arraigned as a-
yes, it has been substantially, the trial has been proceeded. And if there is a, in the trial, now at this stage, court can only consider the material which has been considered during the framing of charge. Now the trial has been substantially proceeded and it's a DW stage. And it has been well settled that prior to the passing of the sentence order or the order of acquittal, 319 can be invoked. When there is a cogent material and is more than prima facie, it unrebuted lead to conviction. If such evidence is there, they can even approach the trial court, your lordship, to exercise 319, your lordship.
But not assail the discharge order. They
Sorry.
can also challenge the discharge order.
Yeah, discharge order also, but your lordship, so far as the material as on that is concerned, your lordship, which we are relying, as per my understanding, so far as my understanding is concerned, the two alternative view is also be possible. Why? Because under 161 statement, The court can, it has been clearly held that the court has to apply his judicial mind, your lordship. The court will not take mechanically because that person has stated, yes, you have to be, charge has to be framed under against you. Court has to apply his judicious mind, considering all the material, the charge sheet, along with the statement of the other witnesses, all the witnesses, your lordship. And after coming to the conclusion, if court find that, yes, there is a material against and which is sufficient and with clearly specify the overt act from the person concerned, your accused person.
And one more thing, he has been named as prosecution witness number 3.
Yes, your lordship.
He is John is the witness for prosecution only.
Yes, your lordship.
You examined him during trial.
Yes, your lordship.
To your question, he answered that these two discharge accused have indiscriminately assaulted. This was not during cross-examination.
Yes, your lordship.
Then whether this statement was contradicted in cross-examination or is it remained as it is?
Your lordship.
You understood my question?
Yes, yes, your lordship. Because yes, your lordship is correct. For 145 has to be invoked if there is a contradiction, because both the statement is not a substantial piece of evidence. 161, even 164.
Whether he was contradicted by the defense side,
But
that
now the your lordship question here is whether,
because they are not facing trial.
yes, whether now the your lordship, the question here is whether we can go into that stage which is not before this court, your lordship.
No, we cannot.
Yes, your lordship.
In this revision petition, we are concerned only with
Material whichever collected during the course of
before
investigation.
saving of charge.
Yes, your lordship. That is the issue, your lordship.
But otherwise, an uncontradicted
Yes.
evidence on oath remains on record against these two accused.
Here, one more thing is there that has to be made as a sterling witness for conviction under 134 as the logic of the section 134. But if it is not consistent, the court cannot give reliance solely on the statement of that witness, your lordship.
But for that,
Court has to look for the corroboration, your lordship.
he has to be contradicted.
Yes, contradicted, your lordship.
And in
Yes.
this case, the question is that they have not even faced the trial. They were discharged.
Yes, your lordship, they have discharged, but your lordship, if this John Tapping, if his evidence, if he given evidence before the trial court, perhaps he has
Okay,
already
let
been.
me know one thing.
Yes.
Suppose this revision fails, then things will go as it is.
But 319 is still there, your
319,
lordship.
it is for the court.
Yes. But it do not bar the accused victim person to
File a petition.
petition, your lordship. It is the court who will exercise his know that it's a discretion of the court. But court cannot reject it.
Assuming that petition is allowed,
Yes, your lordship.
what difficulty it will cause?
The statement, your lordship, the witness who has deposed before the court, they have to be re-examined for this.
Only those who have given incriminating.
Only one accused has given you, or one of the prosecution witnesses given you.
Two.
No, that, your lordship, that I will come to that, your lordship. Why I am saying so? There were not only the John Tapping and the deceased person. There are many other persons were also
So
there.
she may be called again and she may have to be asked whether these two were there or not.
But your lordship, at this stage, if incident happened in front of a person, eyewitness, now the question here is whether he can make a deposition before the court on pick and choose basis. No, this person, he have to give a general statement in chief, what exactly has happened on that particular time. And whatever she has stated in 161.
No, why I am putting this question? When that lady, what is her name?
Yami
When Yami said that
Yami Komi, your lordship.
Yami Komi has stated during 161 that Shan also joined the fight.
But your
He
lordship,
was not cross-examined.
Ex-
Neither the IO examined him further to give details.
again, your lordship, here it is not sufficient. Why I am saying so, your lordship? She says, I saw that even San joined the fight with other boys. Who are the other boys?
Yes. Now, whether
There are, your lordship, John Tapping was there. Deceased person was there. Even 2-3 other accused were there. Your lordship will call out from the charge sheet. It's there, your lordship.
Yes.
So it doesn't confine, specifically doesn't say that this person has assaulted or has a fighting with the, is a altercation with the deceased person. His statement is, her statement is a general statement saying that this son was also involved in the fighting, but with the person who were with the John, and the deceased was not only the person who was accompanying the John. There are other persons were also there, Your Lordship.
Where is the statement of that?
Your Lordship, page 50.
Okay, 50. Page
Yes.
50.
Your Lordship, from the second para from back 6, the area, Your Lordship. The area is visible due to the lighting of the building. I saw that, and even son joined the fight with other boy who had come with John. Who had come with John, Your Lordship. Here also the inference can be drawn, Your Lordship. That person, this person was not come along with John. That person came by himself. And other person who came with along with John.
She was not questioned whom she was referring to. IO had not clarified it during 161, which could have been clarified during trial had they faced the trial.
Yes, Your Lordship. And for that reason, Your Lordship, it's just to create a suspicion, no doubt, Your Lordship. But it's not of a grave nature, Your Lordship. Grave suspicion is not there. And there is no anything more to make it grave one, Your Lordship.
Okay. Yes, Mr. Sonar.
My lord, yes, my lord, a few submission I would like to make.
Just a minute. I took notes. What on piece of paper? Yes, what is the submission?
My lord. My lord, going through all the, my lord, series of the judgments of the, my lord, apex court, my lord. The crystallized, my lord, law point is, my lord, that
We are mainly in this revision petition confined to the question whether the session court was right while discharging those.
Yes.
This is the limited question.
Yes.
We can go through all materials, but we have to answer this question only.
my lord, the crystallized judicial view, the consistently taken by, my lord, the honorable court, my lord, is that, my lord, 227, my lord, the scope of inquiry, my lord, is very limited. It's not saying, my lord, that
sheet of paper here somewhere.
a court has to, my lord, just blindly accept whatever the prosecution has submitted. No. Definitely court will, my lord, sift the evidence, my lord. Will sift the evidence, materials, all the records as submitted by the prosecution. But, my lord, here is, my lord, here is a, my lord, repeatedly the apex court is saying, not in the sense of holding mini trial. This is what exactly what the learned friend has been driving. All the reliability making submission, like as if we are at the final stage of the hearing. No. Says that only to find out that whether there is sufficient grounds. This sufficient grounds has been interpreted in many judgments, whereby says that whether there is a prima facie case or not. Now, my lord, in my case, my lord, as I have already, my lord, read the impugned judgment, my lord. Now the, my lord, learned trial court, what is the reasoning given, my lord, for discarding? Now, our limited inquiry is that, my lord, where in this manner or under 227 scope of inquiry, can we discard the statement of the 164 or 161 of the witness, my lord, in the manner in which it has been done, my lord? Now, the question before my lord is that, can the learned trial court go into the extent of saying that no, this witness is a interested?
That you have already submitted.
Yes,
That
ma'am.
question of reliability, question of
Contradiction,
property
consistency,
value,
it cannot go into.
then what it means. If probative value cannot be gone into,
No.
that means everything has to be accepted.
No, I
Then how, how to distinguish?
Yes, I have a lesson. Now, my lord, now we have to see the law is saying, mother, when we are saying about the probability, we are saying about the broad probability of the case. The broad probability of the case is that taking into consideration all the materials as it is, my lord, whether it was possible by my lord that the accused might have committed the offense or not. Broad probability of the case, my lord. Now, if we say the broad probability of the case, if the statement of the, suppose one witness, my lord, doesn't fit with the broad probability of the case, we may discard. But reasoning, you cannot give that this is the interested witness, my lord. My submission here is, I am not saying that learned trial court cannot discard the statement of the witnesses. No. Can discard. But what is the reasoning, my lord? My lord, what is the danger is, my lord, as my lord has pointed out. Now, before trial, before putting the contradiction to the witness, as required under 162 of the CrPC, 145 of the Evidence Act, my lord, if we declare beforehand, my lord, this has immensely caused the entire prejudice to the entire trial. This is one of the most important witness, eyewitness. Now, if we have declared him interested witness before even the trial has commenced, my lord, now what will be the fate of the even the trial that is pending before against the accused person, main accused person? Tomorrow, my lord, definitely this observation will severely influence the, my lord, result of the pending trial event. My lord, this reasoning, my lord, cannot be accepted. Now, like, my lord, probability. Let's come to the probability issue. My lord, law point says, my lord, for every offense, we don't need the eyewitness only. Without eyewitness also, direct evidence also, my lord, on the basis of the circumstantial evidence also, my lord, criminal trial is held, my lord. Conviction is done even on the basis of the criminal trial. What are the circumstances? My lord, for the time being, my lord, I just keep aside the 164 statement of injury per time. What are the admitted facts, circumstances? These two private respondents were present. There were a group fighting. Person died as of injury. Medical report submits, my lord, showing multiple injury, multiple fracture, my lord. Even assuming the direct evidence, discarding the direct evidence. My lord, all these probability circumstances is not at least to proceed further with that case. We are not convicting him at this stage. It's not in that even for these circumstances taking into consideration cannot be frame charge. If we go by the parameters of the 227, it says, my lord, sufficient, my lord. What else we need, my lord? Let's discard even 164 statement. These two guys were present there with the main accused person. A person has died. There was a group fighting. This is on record, my lord. What else we need to proceed further with the trial, my lord? Do we need that to proceed case against any accused, my lord? Every time we need an eyewitness, my lord? Don't need. Enough materials is there. And here is the, my lord, it is the case of, my lord, apparent, my lord, wrongly, my lord, error is there. Apparent error, this judgment. This is something, my lord, a trial has been held completely in contrary to the settled principle of law, my lord. I will not, my lord, refer to all the subsequent events, whatever happened now. All those, if I refer, my lord, so many encrypting materials have already surfaced against these two expressions also. But I will confine it especially whether this particular order is, my lord, legally sustainable or not. Now, my learned friend has said, my lord, that 319. My lord, 319 is in a very different context also. Now, when the order is, my lord, patently wrong, error, My lord, can we ignore? My lord, what is the danger of, my lord, allowing this order, my lord, as I have said already? This will not only cause immense prejudice, not only for that, the entire trial, my lord. A categorically finding has been made that he is interested. On this account alone, my lord, this order has to go, my lord. Otherwise, my lord, justice will suffer. Now, so far, my lord, my learned BP friend
Yes,
has
this
said
query I
3-1.
made on that day also.
My lord.
When you brand a witness as interested witness before trial begins.
Yes.
Then whether is it not prejudicial to the prosecution side that the trial court at the time of framing charges or discharging two of the co-accused has branded one of the witness as interested witness who happens to be one of the prime witness of the prosecution side. Then during final judgment with regard to the accused who is facing trial, on what footing the court will take the evidence of John Tapping? Because court has already stated he is an interested witness. Now whether on his testimony the accused who is facing trial, is there any possibility of convicting him?
Not solely on the basis of his statement. If once he has
The
been
other witness.
taken as
No,
interested
no,
witness.
my question was different. Question was, can you brand a witness as interested witness before trial begins?
No, Your Lordship. At this stage, it's not permissible.
But your submission was, even if he is not regarded as interested witness,
Yes.
sufficient materials are not there.
Yes, Your Lordship.
Against these two.
Yes.
Okay. Okay, enough.
So far, my lord.
Mr. Sonar, any, how much time more?
My lord, then, my lord, I will conclude 2 minutes.
2 minutes.
2 minutes.
You take 5 minutes.
Okay, my lord. I'm getting that. My lord, friend said 319. Constitutional bench judgment is saying, my lord, 319, my lord. The person, my lord, who has already undergone investigation, my lord, and thereafter is discharged, my lord.
Hardeep Singh Sukh.
Yes, my lord. Hardeep
Sukhpal.
Singh, my lord. Para 116, my lord. Para.
What it says?
2014, volume 3. 2014, volume 3. Yes.
2014, volume 3. You tell me the citation.
My lord, I just read small.
What is the citation?
My lord, 2014,
Volume
volume 3,
page
number, my lord, page number 92. It starts from 92, relevant, my lord, page number 141, my lord. Para 116.
What
Just
it-
read, my lord.
what it says?
Small, sir. Thus, it is evident that power under section 319 CrPC can be exercised against a person. Now, thereafter, saying, not subjected to investigation, or a person placed in column 2 of the charge sheet, and against whom cognizance had not been taken, or a person who has been discharged. So now the saying that this 319 cannot be exercised against a person not subjected to investigation.
No, but the public prosecutor has referred to
volume 3.
a judgment reported in 2023 9 SCC. That is Sukhpal Singh.
It's small bench. This is a constitutional bench.
That
This
is
will
small.
override, man. This is a constitutional bench judgment, my lord. Then that judgment would be, my lord, per inquiry of mine. Not considered the constitutional
No,
judgment.
that constitution bench judgment does not say that the person discharged cannot be again made a.
It's saying, my lord, that discharge is
Wait.
saying in a different category. Here I am. My lord, judgment is there. Kindly take 116, para 141. Page 141, my lord.
Yes.
My lord, may I read, my lord?
Para? Para?
116.
Yes.
Thus, it is evident that the power under section 319 can be exercised against a person not subjected to investigation or a person placed in column 2 of the charge sheet and against whom cognizance had not been taken or a person who has been discharged. However, concerning a person who has been discharged, no proceeding can be commenced against him directly under section without taking recourse to provision of section 305 read with section 398. These subsequent sections, it is in a different context. This section 305, it deals with the question of, my lord, in the complaint case, when the magistrate stops the further proceeding, my lord, then that discharge, my lord. It is in that context, says, my lord, that, okay, 319 can be exercised, but there should be recourse to provision section 300 and 398 has to be taken. But,
CRPC.
305. Section 300 subclause 5. A person discharged under section 258 shall not be tried again for the same offense except with the consent of the court by which he has been discharged. This is in a completely different context. Then 398 is a different context. Power to ongoing.
No, that is what the submission of Mr. Ete was submitting, that for bringing the accused who has been discharged, an inquiry may have to be held. That is under section 398.
But 398 inquiry, my lord, it is in a different matter. 398 in regarding the complaint case, not in respect of the, my lord, well, the accused is discharged under 227. That is why, my lord, 398. We have to read the 398. On examining any record under section, High Court or the Session Court may direct the Chief Judicial also and so sorry to make the or direct subordinate magistrate to make further inquiry into any complaint which has been dismissed under section 203 or subsection 204. Now, when the complaint is, my lord, dismissed and the accused is discharged, then this power can be accessed on two count only, my lord. Under section 300 subclause 5 and another is under, my lord, section 398. Not in every case of discharge. This is only the two conditions when, my lord, a discharge accused can be summoned under 319, but not in all cases. Okay. Well, now this part, my lord, so far. Now, my lord, another, my lord, submission, my lord, regarding this 301st section. Now, for this alteration of charge, definitely, well, still the trial is going on, my lord. I can file the application for that one. That alteration of charge will, if materials is there, definitely that alteration of charge will be done. This is not that you will trial. Or this is not the case, my lord, in 304, submission made by the learned PP. It is not something, my lord, when the charge is made under 304. It is not something, my lord, only in 304, only one accused has to be there. No, my lord. 304, even if we make tomorrow, suppose if these two persons are made to face the trial, my lord, for the framing of charge, if taken, my lord, then, my lord, even we can argue for the, my lord, consideration of the framing of the charge under 302, my lord. And if learned trial court doesn't accept that contention, we can always challenge that one. We have an option, my lord. For alteration of charge also, we can file the application. That's why, my lord, we will be filing application for even alteration of charge. Because 302 is something, my lord.
Whose alteration charges?
From 304.
No, against which accused?
Now, my lord, again, suppose, now, my lord, if my lord allows my application, then there will, my humble prayer will be, my lord, here, this is a case of 301. 2. Because 304, what will happen, my lord? That because tomorrow, suppose if materials come, that there is a 302 material, then it will be difficult once 304 is charged. But there is no harm. If 302 is, my lord, frame, if material is not there, my lord, definitely, my lord, there is no harm. They will be convicted under 304.
But for 302, material has to be there.
My lord, there is, my lord. That's my prayer, my lord. This honorable court maybe please to pass this order, my lord. Then 302 charges, maybe, my lord, frame and, my lord, ask the, my lord, direct the learned trial court to proceed, my lord, against these two accused persons. My lord. And, my lord, so far this 227, my lord, one judgment, 2010 9 SCC, Sajjan Kumar, my lord. 2010 9 SCC. Page 368. Para 21 and 24, my lord. I will not read out the judgment, my lord. This is dealing with 227 and 220. All these guidelines have been given, my lord, considering that Profulo Kumar case, my lord. How, under what circumstances it has to be considered. Then, my lord, not sufficient ground, my lord. 2008, volume 10, SCC 394. My lord.
Volume 10.
Volume 10, SCC 394, para 16, my lord. And, my lord, this is the case where the, my lord, IO, after investigation, had filed the charge under 302. And here, learned PP is not supporting its own state prosecution case. Here is the case after investigation 302, charge sheet was filed. And even if, my lord, finding of the IO or some materials are there, it's enough, my lord, so far.
Okay.
With this, my lord, I conclude my this.
Okay, heard Mr. R. Sonar, learned counsel for the petitioner, also heard Mr. T. Ete, learned additional public prosecutor, as well as Mr. K. Poshi, appearing for the private respondent number 2 and 3. Hearing concluded, judgment reserved.
Deeply obliged.
Deeply obliged.
Staple.
So, I think. CrPC.
39.
Yes, well, this is a very open and set case. I think my 39. My mine is 43. Sorry, man.
39. Mr. Tado is not there today. Ginny, Mr. Ginny, what is your submission?
Lordship, I would like to urge that the senior counsel maybe submit his argument, Lordship, today itself. Because tomorrow, because it's half an hour left, Lordship.
How
So
much time will you take, Mr.
Tomorrow, Lordship, I and this PP will be submitting on argument, Lordship.
Okay.
No, Lordship, that would be better.
Then,
Lordship.
then we'll hear you.
Yes, Lordship. Good.
How much time will you take?
I cannot say. I cannot say.
Today you have to say. Because you have completed the facts.
Yes, Lordship.
Yes.
You will be submitting on law.
Law.
So you take the remaining time today, 1 hour.
Yes. Half an hour. Yes.
Then we'll hear, fix it tomorrow again.
Yes, Lordship. Tomorrow will be final, Lordship.
Then there is a probability of Mr. Tado will be coming tomorrow.
My lord, actually, I have just called him. He's he's in Guwahati. He has been admitted for some treatment, your lordship.
Oh.
So he's saying that it will take 1 week, so it may be fixed after 1 week.
Then it will be.
Our difficulty may be considered at least, your lordship. Sometimes prosecution side may be difficulty may be considered.
Then we are adjourning it.
Adjourning means I think we will release from part of it.
It has to be released.
But I wanted to complete my part. Na?
I also wanted to hear you.
I'm sorry, extremely sorry.
Heard Mr. M. Pertin, learned senior counsel, assisted by Mr. M. Pertin, learned counsel for the appellant. Also heard Mr. T. G. Ginny, learned counsel appearing for the respondent number, learned legal aid counsel appearing for respondent number 2. Mr. T. Ete, learned additional public prosecutor, making submission on behalf of Mr. G. Tado, learned additional public prosecutor, who was conducting this case, has submitted that Mr. Tado is indisposed and prays for an adjournment on that ground. Considering the submissions made by learned Mr. T. Ete, the prayer is allowed. Let this case be listed again after a week on a date to be fixed by registry. This case is released from part heard.
Deeply obliged, Your Lordship.
Much obliged. After week, one.
After a week,
2 weeks.
Your Lordship.
1 week.
Okay.
No, no, 1 week I will begin with.
After 2 weeks.
After 2
After
weeks.
2 weeks.
Session 4.
On a date to be fixed by registry.
Deeply
The
obliged.
case is released from big part heard.
My lord, this is a very, my lord, small matter, my lord. This is open and said in case, my lord. This order before passing 133 order, my lord. I won't go about the merit of the whether this is a public or private nuisance, my lord. The order under 130 has been passed, my lord, without holding the preliminary inquiry and without, my lord, issuing the so cause notice, my lord, giving opportunity of hearing in violation of the statutory provision itself. And on the first day itself, the absolute order has been passed, my lord, under order this 133. May I take, my lord, impugn order? I think my learned page number 34. On that account, if my learned friend concede, I think then this matter can be disposed on that account itself.
Yes, Your Lordship.
Page number
Okay.
30, 34, my lord. Annex 1. May I read, my lord?
Yes. CRPC, CRPC.
Whereas it has been reported that you have illegally constructed new structure at Eco Dumbing Riotala, which could cause the disharmony between Simong and Memba Kamba communities and thereby lead to serious law and order. And whereas as per the meeting minutes of has CM so and so, alternative site is to be relocated by the DC Upper Siang in consultation with Simong community and stakeholder for construction of guest house and Gompa prayer and submit the proposal to government. And whereas in pursuance of meeting minutes so and so, a meeting was convened by DC office Upper Siang in Kyong on so and so, in which it was reiterated that Simong communities has agreed to relocate alternative site for construction of guest house and Gompa, which shall be used for pilgrimage purpose. And whereas the DC Upper Siang issued wide armor that a member Kemba to nominate 5 members each to accompany DC Upper Siang to Eco Dumbing Riotala for relocating alternative site for construction of guest house and Gompa. And whereas the chairman of Eco Dumbing Forest Development Committee has submitted Kebang decision dated in connection with Eco Dumbing Riotala dispute between Simong Village and Chime Yangsang Pemakot Welfare Society, claiming that the Kebang decision in their favor. And whereas the structure constructed by you in Eco Dumbing Riotala are in violation of the meeting of minutes of so and so, DC minutes so and so, such arbitrary action on your part is likely to cause serious law and order and disturb the age-old communal harmony between the Simong and Memba Kamba communities residing in Upper Siang district. Therefore, taking all the facts and circumstances, you are hereby directed to remove this said structure in 14 days from the date of the issue of this order to facilitate the early relocation of alternative site in consultation with Simong communities and stakeholder for construction of guest house and Gompa prayer hall as per the decision of the meeting dated so and so to avoid any serious law and order. So and so. Well, just brief facts under what circumstances this order was passed. This happened, well, there is a place called Riotala area. So this Riotala, there was, since time immemorial, this petitioner party, they profess this Buddhist religion, my lord. They are from the Buddhist religion, my lord. So they treat this as a abbot of Abeletoscar, who are one of the recognized deity in the Buddhist religion, my lord.
Abode of?
Abbot of this Abeletoscar, one of the deity, it is recognized by the Buddhists. So peace and who spreads universal love and affection. So, my lord, this is a pilgrimage site so far the petitioners party are concerned. They are the Memba and Khamba communities of, my lord, Upper Siam district, my lord. So they profess Buddhist religion. So, my lord, this is considered as a pilgrimage site. So every year, my lord, the people who profess Buddhist religion, my lord, they go there, my lord, after making 2-3 days trekking, my lord, they go there. So earlier, my lord, they had there this gompa constructed, and they placed there one this idol of this deity there, my lord. And they have been praying since.
What is Gompa?
Gompa, my lord, this is Buddhist temple. I should say, my lord, where the Buddhists, where they make the prayer, my lord, that's called Gompa. Okay. Because as we say, my lord, temple, so far the Hindu is concerned, mosque, so far is concerned, Muslim, my lord. It's the same, my lord, it's called Gompa. So for the Buddhist, my lord. Okay. So, my lord, they constructed one Gompa in the year 2019. They were praying. Then what happened, my lord? All of a sudden, this community member of Simom community, another community which is called Simom. These members of the Simom community, they started claiming that land as their community. And when they started claiming, my lord, then, my lord, issue crop up. Then administration, all they have to interfere. Then what the Simom community did is, my lord, they burn out the old compound. They completely desecrated and burned to ashes all this earlier Gompa, our God. Then, my lord, what we did is, my lord, since, my lord, our old standing Gompa was burned down, we went there and constructed a temporary Gompa again. Because earlier, my lord, since last 2019 onward, we constructed Gompa, all Gompa was in existence. The other party, even if they claim that this is their property, my lord, they could not have resorted to this kind of, my lord, forceful burning and destruction of all the Gompa, my lord. But they did it. Thereafter, my lord, we constructed a new Gompa. Now, after this, my lord, under the pressure of the other party, my lord, this order has been passed under 139 saying, here, my lord, you are directed to remove this said structure in 14 days. My lord, now the question is here, my lord. This power under section 133, my lord, if I see the scheme of the CrPC, my lord, provision of the CrPC, my lord, this power cannot be exercised, my lord, for the private land dispute between two parties. This is a complete case of, my lord, civil dispute between two parties. So for the land is concerned. Now, and this power can be exercised only in case where there is a public nuisance. And, my lord, section 133, it says, when it can be said public nuisance. My lord, may I read section 133?
Yes.
Public nuisance, my lord. Conditional order for removal of nuisance. One of the, my lord, main ground of assailing this order is that removal, that order can be also passed conditional order. Here is that, my lord, at a time without hearing, direct order for removal has been passed. I'll just read. Whenever a district magistrate or a subdivisional magistrate or any other executive magistrate, especially empowered in this behalf by the state government, on receiving the report of a police officer or other information on taking such evidence, if any, if he thinks fit considered that any unlawful obstruction or nuisance should be removed from any public place or from any way, river or channel which is may be lawfully used by the public. This A, my lord, doesn't attract in my case, my lord. This is not something of unlawful obstruction or nuisance in public place, my lord. Not, my lord. Now B.
That place, land is not a public land.
No, no, no. it is something, our consider this is our community land, my lord. This is something very far away from this all human settlement, my lord. 3 days, 4 days, my lord, trekking by foot, my lord. There only one reason. Nobody stays there, my lord. It's basically a pilgrimage site. Now, and my lord, how, my lord, when already our Gumpa was there earlier, my lord, if that was burned down, my lord, if I construct a new Gumpa for prayer, my lord, I don't understand how it will be a nuisance, my lord. There cannot be nuisance at all, my lord. Now, second, my lord, condition. That the conduct of any trade or occupation or keeping of any goods or merchandise is injurious to the health or physical comfort of the company, my lord. It is not there in my case, my lord. C, that the construction of any building or the disposal of any substance is likely to occasion conflagration, explosion should be. This is also not there, my lord. That any building, tent or structure or any tree in such a condition that it is likely to fall and thereby cause injury to person living or carrying on business. Well, this is also not applicable in my case. E, that any tank, well or excavation adjacent to any such way public place should be fenced in such manner. My lord. This is also not there, my lord. That any dangerous animals should be destroyed, confined. This is or not there. Now thereafter, such magistrate may make a conditional order. Now here I pause here for a while, my lord. Suppose, my lord, assuming, otherwise, my lord, this A to F, my lord, not a single condition is fulfilled in my case. Not ever, my lord. Now, for the sake of argument, even if I assume, my lord, that A to 5, one of the clauses is attracted in my case, even then, the magistrate cannot directly pass the order in the manner in which the impugned order has been passed. Why, my lord? The law says, my lord, first, my lord, the magistrate may make a conditional order. Conditional order, I will just read, my lord, requiring the person causing such obstruction or nuisance or carrying on such trade or occupation or keeping any such goods or merchandise or owning, possessing or controlling such building, tent, structure, substance, so and so, animal to within a type to be fixed in the order to remove such obstruction or nuisance, number one. To desist from carrying on or to remove or regulate in such manner as may be directed such trade or occupation or to remove such goods so and so. Third, to prevent or stop the construction of such building or to alter. Fourth, to remove, repair, support such building, tent, so and so. 5, to fence such tank, well or excavation. 6, to destroy, confine, dispose of such dangerous animal in the manner provided in the setup. Or, if he objects to do so, to appear before himself or some other executive magistrate subordinate to him at a place to be fixed by the order and so cause in the manner herein provided why the order should not be made absolute. Here I pause. Now, this order, my lord, in the manner in which it passed, my lord, cannot be passed, my lord, because the statutory, my lord, provision says, my lord, the conditional order should be first passed.
What is conditional?
Conditional order, at least saying, my lord, you should remove your, assuming, my lord, that
within such time.
Such time, if not, so cause why you will not do. Give
That
your explanation.
Second portion is not.
Yes,
there.
my lord, not much.
14 days time was given.
But not saying if you don't want to do, why you don't want to do. Because, my lord, without hearing me, how the magistrate can come to the conclusion? This is, my lord, basic. I think my learned friend will concede to this part. Other part, my lord, will not required to go into whether it is public, private event, my lord, because that after opportunity we could have, my lord, satisfy the magistrate, my lord. No, this 133
Yes.
cannot be involved.
That is not there.
Yes, your lordship. There is a procedural error and that will vitiate the proceeding under 133 because the mandatory procedure under section 138 of the CrPC is sine qua non to initiate proceeding under 133, which is not there in this order, your lordship.
138,
your lordship. Procedure where he appeared to show cause. And it has been held by the Honorable Supreme Court in
You have some judgment?
Yes, one judgment is there, your lordship, to that effect.
I have also.
You also have judgments.
My lord, I have, my lord, what is public nuisance? What is preliminary order? How
we are not going into that.
Yes, yes.
My
We are
Here
only
the procedural
My lord,
irregularity appears.
then
to-
I will, my lord, this preliminary order, conditional order, how it has to be passed. my lord. Same. Okay, my lord, we are in the same boat, it seems. my lord. At least now we are in the same boat.
Rarely.
Lordship.
Okay, this petition is allowed. I will pass detailed order in chambers.
Okay, your lordship. Deeply your
If-
lordship.
Give this to in the chamber. So that door is locked.